There's been much in the media regarding sexual abuse of minors of late. In the normal course of events, such abuses are subject to the rule of laws that are current and evolving. It would seem, however, that many religious leaders somehow consider themselves to fall outside the lawful standards that apply to the rest of the community. This despite them holding themselves up as pillars of morality. Unlike the laws that apply to the rest of us, the laws of religion, of course, are ancient. Recently, virtually every religion has been exposed as hiding sexual abuse, including Catholic, Anglican, Salvation Army, and Jewish clergy. It's interesting to wonder which religions have escaped exposure thus far, and how much they are nervous about being exposed. Hopefully, with time, they'll all be exposed and prosecuted accordingly. With this topic in mind, it gives me great pleasure to introduce our guest speaker this evening, Dr. Andrew Morrison. Andrew is a senior counsel, has served as an acting district court judge, and holds the rank of colonel in the Australian Army Reserve. He's a spokesman for lawyers' groups. This evening he'll discuss child abuse by religious institutions exposed and addressed in two sections. The first part will be what religious institutions have done to avoid responsibility and liability for child abuse. And part two, the Royal Commission into child sexual abuse. I'd ask you all to make Andrew welcome in the normal way.
Thanks, Steve. Can I say that I'd much prefer to keep this fairly informal tonight. There are a number of reasonably technical areas I want to go through, but I'll try and keep them as simple as I can. But if at any stage anyone has any questions or comments or wants to throw something into the ring, feel free to speak up. Don't feel inhibited in the least. It should be a two-way dialogue. I'm certainly open to discussion and debate upon many of these issues. What I want to cover in particular is matters which the Royal Commission has been examining with some care, and my own particular field, which is the liability of institutions, not just churches, but institutions generally, for child sexual abuse. And I came into this area quite by chance in many ways. I was brought into a case called Lepore, which was a case where a teacher in a government school abused a child, I think then of 7 years of age, in a storeroom off the classroom. And that case was run without my assistance at first instance. The district court judge, well, to use a technical expression, buggered it up pretty badly. He found there'd been abuse, but not how much and not what the nature of it was. I came in for the Court of Appeal, and I argued successfully, as it turned out, at least with the majority in the Court of Appeal, that educational institutions such as the State of New South Wales owe what's called a non-delegable duty of care, which was effectively meant strict liability. Well, we won there. That led to an appeal to the High Court, in which we were the respondents, and the High Court preferred the argument being put up by the State of New South Wales on that, but our alternative argument, which was that even if they were not liable on a non-delegable duty, they were liable vicariously, that is, servant and master relationship, and the majority in the High Court, 4 out of the 7, was persuaded that at least was open to argument, and they couldn't decide it because the first instance judge had not made the necessary findings, so they sent it back for a retrial. That didn't prove necessary because the State of New South Wales threw significant sums of money at us, and we resolved the matter. But after that, for my sins, I was, from 2003 onwards, doing this area of work. And ultimately, I appeared in the case of Ellis versus Pell, in which I'll describe our vicissitudes in a moment, and perhaps that's where we go now. John Ellis was an altar boy in the service of a priest appointed by the Archbishop of Sydney, the then Archbishop of Sydney, to a parish in Sydney, initially as an assistant priest and then as a priest. He was sexually abused from about the age of 13. That abuse continued well into his adult life, and in fact, even after he married, the priest baptized his children. It's not an uncommon situation for those who have been abused from being a child, not to realize, not to have insight into the fact that it was abuse, not to realize that it wasn't a loving relationship, not to realize that there was something deeply wrong in relation to it, and not to realize that they have been seriously harmed by it. Sadly, that realization only comes very late in the piece. An Anglican church inquiry, which they undertook to their considerable credit in southern Queensland about 7 years ago, found that the average time of those who had been abused in the Anglican church from abuse to first complaint was 23 years. The Royal Commission has produced its preliminary findings, and they're only the very first step, but on page 158 of Volume 1, if you ever care to dabble in it, you will find that they, after interviewing some thousands of complaints, and not just from churches, but from all other forms of institution, YMCA, Scouts, and various different churches, came to the conclusion that on average the time from abuse to first complaint was 22 years, remarkably similar. Well, John Ellis was a very bright fellow. He did very well in law. He became a partner at Baker and McKenzie, but for various reasons, his relationships with other people started to break down, and he saw initially counselors and then psychologists, and for the first time he started to get some insight into what the cause of his problems were. Ultimately, he was dismissed from the partnership. A psychiatrist said, none of this is confidential, it's all in the court reports, said that his interpersonal relationships were the worst that they'd ever seen. And he then, having lost his career and lost his marriage, sued the Roman Catholic Church, and sued, as was traditional, the trustees of the church. Now, we need to go back a little in history to the situation. Most churches were initially unincorporated in Australia. Most churches asked the state government, as they have in other governments throughout Australia, to incorporate them for all sorts of very good practical reasons. The Roman Catholic Church, under the Act of 1936, asked for a particular form of incorporation, not, I suspect, with any particular malicious intent, but simply because it fitted in with the way they were structured, so that all their property in each diocese, and I think there's 34 dioceses throughout Australia, was held by the trustees of the diocese. So the property of each parochial school, and after all, 18% of all children in Australia attend Roman Catholic parochial schools. We're not talking about Joey's or Riverview. We're talking about the Roman Catholic school down the road. But the trustees of the diocese hold the property of that school. Who runs the school? The Catholic Education Office. The Catholic Education Office isn't incorporated. It has no legal entity. It might receive several $100 million a year in state and Commonwealth grants, but it isn't a legal entity and it is not accountable. It employs teachers. How a teacher would ever sue for breach of contract, God alone knows. But in practical terms, the bishop and bishops in the past have always taken the view that in these matters, if a child was injured at a school, if a teacher had an action against the school authority, the trustees would stand liable to pay, because the trustees held all the property. Cardinal Pell got very concerned when a large payout was made in a particular case. And he decided to take a tough line, and he got a firm of Melbourne solicitors called Cause in, and they gave him the advice that because the church had no legal entity, does not exist in law, it could not be sued, and because the trustees under the particular act could only be sued in respect of property matters and could sue in respect of property matters, they were not liable. So the person who's injured in the old person's home, the person who's injured in the course of charitable work, the child who's injured in the playground at a parochial school, unless the bishop chooses by his whim to say, yes, we will in this case accept that the trustees can be sued. It was held ultimately in John Ellis's case that there was no one who could be liable in respect of the Roman Catholic Church. Now, we sued and succeeded in getting an extension of time to sue at first instance, but on appeal there were a number of findings. One was the church was not capable of being sued as a legal entity. It's too amorphous a body, you can't determine what its size is. Now, in respect of the local bowling club, if it's unincorporated, traditionally the common law has a way around that. You can get what's called a representative order, and you can enforce that order and any subsequent judgment against any member of that bowling club and ultimately force the trustees of the governing body to cough up. And normally you get that order against the senior executive of the club. The church was too amorphous a body for that to be possible. So no success against them. The trustees, no success against them because the Act of 1936 limited their liabilities to property matters, and clearly sexual abuse by a priest wasn't a property matter. No use suing the priest. He was, by the time we got to court, he was effectively gaga and then subsequently dead before we got to the Court of Appeal. But in any event, he'd taken a vow of poverty. Vicarious liability, no joy there, because the church said, we don't employ our priests. Now, that might surprise you, but the church itself doesn't generally pay stipends to its priests. Now, that's not entirely true, but in general, the parish pays the priests out of the collection plate. And therefore, priests, whilst they're subject to the directions of the bishop, are not liable in general, are not in general the servants in the normal sense, in terms of employer-employee, of the bishop or of the church. The end result was that we failed both to get a representative order against Cardinal Pell, and we failed ultimately to get our extension of time because there was no body to sue. And from there, you can see we had very significant problems. But it's important to note that's only in respect of one church. As best I can judge, there is no other church in Australia which runs this line of defence and which is structured in this way. So it's a singular attribute of the Roman Catholic Church. There was last year an inquiry in Victoria in the Legislative Council after a large number of suicides down there in the Diocese of Ballarat after child sexual abuse by priests. Ballarat, where Cardinal Pell had been a senior member of the clergy at one stage. Not that I am suggesting for one moment he was personally involved in any form of abuse, but he must have been aware of the complaints and of the appalling atmosphere down there and of the large number of deaths of former children involved with the church. The evidence in that Victorian Upper House inquiry was, and accepted by the inquiry, that Roman Catholic clergy are between 6 and 9 times, depending on which of the two studies you preferred, 6 times more likely than clergy of any other denomination to abuse children. What is there that's distinctive about the Roman Catholic Church? Celibacy sort of stands out as the obvious answer, but there has been no reputable study to give us a final answer on that, but it does seem like a reasonable hypothesis to me, at any rate. That's a matter of very considerable concern. On the other hand, whilst in Australia we struck this problem, and I must say the legislation in all other states and territories is not identical, but is similar. In other countries, other common law countries, a very different approach was being taken. In Canada, the Supreme Court had to consider these issues in regard to, in particular, vicarious liability. That's responsibility of the employer for their servant. In 2 cases called Basley versus Curry and Jacoby versus Griffiths. And there the Supreme Court of Canada espoused what has become known as the close connection test. If the criminal act which causes the injury is so closely connected with the employment, it's got to be more than just gives the opportunity for the abuse, but is closely connected to the nature of the employment, and there is both vulnerability and a great deal of power in the part of the abuser, and that's given to them by the employer, then in those circumstances, the close connection test says that vicarious liability properly arises. The other case, Doe versus Bennett, was a case where they said, well, how can we be liable for criminal acts? It's no part of an employee's conduct to act in a criminal sense. The Supreme Court says you may not technically employ priests, but you as good as employ them, and that's good enough for us. And if you give them this position of power, then you are responsible even for criminal acts which might ordinarily not form part of the course of employment. If we turn to England and Wales, in England and Wales it's always been a little bit easier with the Roman Catholic Church because the Church there has accepted and still accepts that the trustees in each diocese are the proper body to be sued, so that we don't have that argument. But in a number of cases, they ran the argument, how can we be liable for criminal activities of priests? Both because we don't employ them and because we didn't employ them to undertake criminal acts. This matter came up in a non-Roman Catholic case called Lister and Hesley Hall and went to the House of Lords, then the highest court in England and Wales. In Lister, the head of an institution for boys with a history of behavioral problems systematically abused a large number of those children. There had been a previous case in which the Court of Appeal in England had said, we don't think there can be vicarious liability, your claim fails. The House of Lords said they got it wrong in that previous case, and that the House of Lords said, we will follow the close connection test of the Canadian Supreme Court. And in those circumstances, this man was given authority, power. These children had no one to complain to apart from their abusers. They had no access to the outside world. In those circumstances, it is fair, just, and reasonable that the institution should be liable for the criminal misconduct. Oops. In JGE, the same issue was run in respect of the Roman Catholic Church. And there they ran the argument about how can we be liable for criminal activities. Well, they lost that, as you might expect following Lister. But they also said, well, they're not employees anyway, so no liability. The Court of Appeal, in a very strong judgment by Lord Justice Ward, found that there was liability, that it was fair, just, and reasonable, that the relationship between bishop and priest was sufficiently close to that of employer-employee to make it appropriate that there be liability. In Marga, a very similar situation. There, the priest abused young girls that were being looked after by nuns, and the priests were given access, and this particular priest abused girls of 7 and 8 who sued, and the Court of Appeal said, we think following the close connection test you should be liable. However, special leave, or I shouldn't say special leave was sought to go to the highest court in England and Wales, which is now the Supreme Court, the successor to the House of Lords. That was refused on the basis that another case was about to determine these issues in the Supreme Court. And that was the other case that's mentioned there, Catholic Child Welfare Society versus various claimants in the Institute of the Brothers of the Christian Schools. That case related to an institution in northern England, a school which had originally been run by the De La Salle brothers. And that school had a history of abusing literally hundreds of boys. It was taken over by another body early in the 1970s, but the De La Salle Institute continued to provide the headmaster and usually about 4 or 5 clergy. But the relationship between De La Salle Institute and clergy was not that of employer-employee. Their salaries, for example, weren't paid to them. There were various other peculiarities about it. A large number of the abused children sued and were successful in the Court of Appeal, but they were successful only against the institution which had taken over the running of the school. And that institution was peeved that the De La Salle Institute, whose brothers had been prominent in the abuse, wasn't paying its share. So they were the ones who went to the Supreme Court. And the Supreme Court then had the opportunity to deal with these matters. And Lord Phillips, to use the correct terminology, handed down a judgment in which the whole of the Supreme Court agreed, and in which they said the test is not whether or not there was technical employment. The De La Salle Institute should be liable for its share of the responsibility because the clergy that it provided were there to promote its objects, and it gave them the opportunity. And applying the close connection test, the children who were abused were put into their care and their hands and had nowhere else to turn. And in those circumstances, not merely the school authority, but the De La Salle Institute should both be liable. It's a very powerful judgment, one which hasn't yet come under the consideration of our High Court. We didn't get special leave in Ellis. Had the various claimants' case been handed down before the Ellis decision, I suspect a very different outcome might have occurred. There was one other aspect in the Ellis decision, and that was that there is a very old concept called corporation soul, which is a form of traditional incorporation. We argued it in Ellis in the Court of Appeal. We were unsuccessful. It's a concept that dates from prior to the Reformation, when the Roman Catholic Church in England had its own legal entity, its own courts, the ecclesiastical courts, and was not, and was in fact immune to the normal common law legal system. Indeed, if you could read and write in those days, because normally only clergy could read and write, you could claim what was called benefit of clergy and avoid being dealt with by the common law courts. Doesn't quite work like that these days, but those matters didn't assist us because the Reformation was held, unlike the position in Ireland, unlike the attitude taken in the United States and in Canada, to mean that the corporation sole argument was no longer available to us. The other case I've referred to there, PAO, is a case where children in a school in southern Sydney, run by a particular branch of the Roman Catholic faith, which is not incorporated. Some are. Jesuits, for example, have their own Act of Parliament. If your child goes to Riverview or Joey's, you do have someone to sue. Bad luck if you're one of the 18% that go to parochial schools. But in the PAO case, a number of children sued those who held the school's property in respect of their abuse, and they failed. And they failed on the basis of the argument in Ellis. Before I come on to limitation issues, can I, after that rather complex diatribe on what is by no means an easy area of law, can I ask if anyone's got any questions or wants to know any more about the complexities of this issue? Please.
Do these cases, are they all 23 years plus after the original offence?
John Ellis came forward, I think, probably about 15 or 20 years after his abuse. PAO, about the same. The overseas ones, yes. The vast majority of victims, it's decades later.
And say, for instance, here, if one of the bar staff sexually abused me, for instance, who would be sued then?
Well, that's a really interesting question. I was just advising on a case today, after looking at some CCTV footage of a bouncer who beat up a patron who was excluded from a pub, I think because he was winning too much money from the TAB in the pub. And funnily enough, that money had disappeared by the time he got to hospital. It was thousands of dollars. And the problem in that case was that the bar staff were employed by a security company, and the New South Wales Court of Appeal has said that vicarious liability means that you can only be liable in respect of, well, that is, only one body can be liable. You can't have vicarious liability for both the publican and the security company. So if you get beaten up by the bar staff, yes, you've got a remedy against the licensee. If you get beaten up by the security company, your remedy is against the security company, which in our particular case didn't have insurance and is in liquidation. So unless the particular bouncer has property, it doesn't look too flash, sadly, for the brain damaged client. But that's an indirect way of answering your question. But
the bar staff themselves, are they liable?
Oh yes, they can be liable personally.
So you don't sue if they haven't got any money?
Not if you've got any sense, no. It doesn't seem to be a very rational approach.
But of course they'd be criminally liable.
They may be criminally liable, and they may not be too. It depends. Usually you find that quite a lot of people get together to provide very helpful evidence for each other in respect to the criminal proceedings. These days with CCTV footage, that helps enormously, although the CCTV footage from the pub, which was taken outside, had a peculiar gap of probably 20 seconds in it. Just extraordinary, isn't it, how these coincidences arrive during the period when he's first thrown to the ground and then when he's punched and goes down again and when the boot's put in. Fortunately, the council's CCTV footage was okay. Unfortunately, when the criminal trial went on, they weren't smart enough to work out how to use it. The format of the council footage was different. And I must say we had some trouble looking at it today, but we managed to find a machine that would show it. But all those sorts of problems arise, and there's been at least 2 cases in New South Wales in recent times, one down in Wagga, one in northern New South Wales, where people have been accused of assaulting police in police stations, and the CCTV footage has been found to be severely damaged. But with great skill it's been restored, and that showed that the person is lying supine on the ground, handcuffed, and the police are putting the boot in. I sincerely hope that some charges are laid. Unfortunately, there's always a hint in these matters of police supervising police. Do you see real justice? But complaints, very serious complaints, have been made by the magistrates who dismissed the charges and made adverse findings about the police. So there are all those sorts of issues.
Carrying on from that man's question, do people often sue the abusers then, as well as the church, or do they just focus?
The answer is it depends. If you're dealing with clergy, not often. Sometimes they're dead. Usually they've got no assets. Because the lapse of time means that often they're not available as a witness, but very rarely. But you might, in respect of some churches and some other institutions, if a person appears to have assets, you can do a search to see what land holdings they have anywhere in Australia. So that assists. That's one possibility. Yes. The question was about the propriety of taking boys as young as 12 away to a seminary which might well be interstate. Look, the proprieties of those things are moral issues, in which perhaps is a little outside my field as a lawyer. But I could say this, that there's been a number of cases where parents, particularly in the Roman Catholic Church, are and particularly in the 1980s, rather less so when these things have come to light, have happily consented to their sons of 12 or 13 as altar boys being taken off with a priest to go touring around rural areas on a weekend. And if you think of the Father F matter, that was the priest's opportunity to abuse the altar boys. Often the boys would not complain to their parents because they were utterly convinced their parents would not believe them and would just punish them. And that may well have been right. I did one case up in the Port Stephens area where a teacher in a Roman Catholic primary school had abused children. That teacher had been thrown out of the government system for abusing a number of boys in Maitland at a school. and he had a conviction against his name. He had been employed by a bishop from the Catholic Education Office to whom he had disclosed his history of abuse. He was then sent to a school. There were complaints made about him. The parents were told to pull their heads in, but he was then moved to another school. Similarly, complaints, and he's moved on to another school. And finally, at the school at which ultimately it all came to a head, it wasn't until a parent who was a solicitor was driving his child and other children home from school one afternoon and heard one of the children saying, Mr. So-and-so had his hand down little Johnny's pants again. And he took them straight round to the police station. Well, what was the response of the local Roman Catholic community? Was it to support the victim? No, it was to ostracize them. And the teacher, who was then taken to court and had a criminal conviction, continued to serve in the local church, and it was the family who had complained about him who were ostracized by the school and the church. It's a singularly interesting attitude, but it's one in respect of a church which has always given a huge amount of authority and power to its clergy in a way which perhaps not many other religions do. But we should also say that it's not just churches. I've mentioned school authorities, including government schools. It also applies to the Salvation Army. I had a case of appalling abuse over in South Australia in the early 1960s, in which we managed to succeed in getting an extension of time, despite the very long period of time involved. The abuser is now doing a long period of imprisonment, but it took, 40 years to jail this villain. And it wasn't just sexual abuse. The physical abuse was horrific, putting children in cages, denying them food, denying them blankets, beating them if they complained, beating them if someone from outside saw the bruises on them. When one boy's sports teacher at the local school saw bruises on him and raised it with the Salvation Army, what was their response? To beat him, to put him in a cage and keep him there until the bruises went away before they let him go back to school. That was their response. Horrible. But it's not, as I say, it's not just them. There are other institutions as well. Scouts Australia, YMCA, Swimming Australia, as we've just been hearing. There's a horrific history, sadly, in this country. And we know from the Murphy and other inquiries in Ireland that there's a similar history there. And the same is coming out in England, particularly since the English Supreme Court has opened up the opportunity for litigation. A large number of these cases are coming forward, and the incidence of false accusations seems to be very small. Now, it used to be thought that children would tell lies about teachers and about others. I'm sure that on occasions it happens, but generally speaking, even with the very high probative standard required beyond a reasonable doubt in a criminal court, generally speaking, there's been convictions. And I'll come back to this issue of the swimming association, and my colleague at the bar who recommended against prosecution, Ms. Kinnean, who also conducted the Special Commission of Inquiry in New South Wales. Now, you had a question.
Just getting back to the Ellis case for a second, just give us some hope. Is the Ellis defence finished? There is no further avenues for compensation. It's just a bit gloomy for me at the moment. Is there any can that case be reopened in light of some of the cases that you mentioned in England or is it over? Is there any way that the Catholic Church can be sued?
It's over. That case is finished. For all practical purposes, there's no way it can be reopened. That said, they ended up not giving him compensation, but they spent $1.5 million on fighting it, and they have paid about $500,000 or $600,000, not as compensation in the ordinary sense, but for assistance to John Ellis. So it's cost them a couple of $1 million, and they could have settled it for less than half that. So there's some justice in that, but it's pretty rough justice, is the short answer.
In answer to a question which was asked was whether the Ellis defence remains valid, and
the question is complex in a number of ways. First of all, no defence has to be pleaded or taken. It's a decision taken by the Church, and in the Roman Catholic Church, that's a decision in each diocese for the bishop of that diocese. And as Cardinal Pell has made clear, even though he has on occasion purport to speak for the Church, he doesn't have authority to bind bishops in any other diocese. Now, in most dioceses, the bishop has not chosen to take the Ellis defence. In the Maitland-Newcastle diocese, for example, where there have been hundreds of claims, to my knowledge they have paid out $20 million plus so far in that diocese alone in compensation. In the Archdiocese of Sydney, Cardinal Pell's diocese, the point is being taken and resisted to this day, and there's a claim going on which I don't think has prospects of success as the law presently stands. Now, the position is complicated in a number of ways. The legislation of 1936 was amended in 1986. That was subsequent to the abuse of John Ellis, and we don't know whether those amendments, which were not intended to deal with this issue, have made any difference. The Church says they haven't, and it isn't liable, but the answer is we don't know. I suspect the answer is that it probably doesn't make a difference. The separation of the Church's enormous property assets, I suspect, is still effective. There are parts of the Church which can be sued. If you need to sue some aspects of the Church, such as the Jesuits or some of the other brotherhoods, they may have their own separate Act of Parliament and be liable. But even then, it's difficult. There's one school in respect there's been a large number of claims where we have been wholly unable to work out who it was that was technically the owner and running of the school in the 1980s. Now, this is a private school receiving state and Commonwealth grants, employing staff, deducting tax to the ATO, and yet they say, well, we can't answer your question as to who technically was running the school at the time, and besides, all our records have been seized by the police for the purposes of prosecuting 6 or 8 of our former staff members. Now, in the last couple of weeks, the solicitors for the Church, in fact for Catholic Church Insurance, have actually come to us and said, look, let's put that question to one side. We want to talk settlement to you. My suspicion is, however, that when it comes to a settlement conference, they'll be saying, well, you've got a technical problem ahead of you and you may or may not be able to win. So the Ellis defence is a very effective weapon in any settlement negotiations, but it's by no means universally used or available, and where we are in the Archdiocese of Sydney is the heart of the problem, and the heart of the problem lay, of course, with Cardinal Pell, who's off now to his $30 million palace paid for by the parishioners of the Archdiocese, where he is over in Rome trying to sort out the very corrupt Vatican bank and financial affairs. Now, he may actually be quite good at that, but rather better, I hope, than he was at dealing with interpersonal relationships in his own archdiocese. But that means that you don't know whether they'll take the point. You hope that in other dioceses they won't. In the Archdiocese of Sydney they certainly will. And that means that a legislative response is required. And I'll come back to that in a moment. There was a question asked while we were having that short break, a very interesting one, as to whether I thought there was any, that the majority of abuse being of boys was some sort of Abrahamic response. There were some studies done, interestingly, for the Victorian Legislative Council inquiry, and it was a very good inquiry, actually. I had grave doubts about its utility originally, but it turned out to do a very good job. And they had some evidence from one PhD student and one psychologist who'd done some very good studies in which they interviewed Roman Catholic priests after they had been convicted, so they had nothing to lose in telling the truth. And they asked them the questions we'd all like to know: did you join the priesthood in order to abuse children? The answer was universally no, and I think that's probably genuinely the case. The fact of the matter is they came in so early to the seminaries that they were sexually immature. They never had the opportunity to grow up sexually. They had little idea of what goes on in the world, and the only examples of sexual behavior they saw in a seminary were obviously between males. So, small surprise if they turn out to be more likely to abuse boys than girls. But it's even more obvious than that. Parents sending their altar boys off with priests for the weekend, or altar boys being alone in the presbytery with priests. I mean, we might think that's crazy today, but 10 years ago, as recently as that, parents were very willingly consenting to sending their boys off with priests in full trust of the priest's behavior. Opportunity is the other aspect. So, in my view, sexual immaturity, celibacy, and opportunity are the explanation. And it's not as if priests haven't abused girls. We know they have. In the McAlinden case, he was quite flexible in his approach. He abused girls when he could just as much as he abused boys. That's up again in Maitland, Newcastle. The case of the Fosters, you may or may not be aware of their case. They've written a very telling book about their experience of the church, and they'll be giving some evidence to the Royal Commission in respect of the Melbourne approach, when Pell said he will come back from Rome to give some further evidence. Their experience was they allowed priests to go and tuck their little girls into bed and go up and pray with the girls at night. I mean, those of us not from that background look on that with horror, but it's the way many devout Catholics looked at things. And that trust was obviously abused in their case, and one of their daughters committed suicide, and the other is now brain damaged. Very sad. All of that's interesting, but the legal problems continue. And the legal problems don't stop with the problem, the problems in relation to finding an entity to sue and establishing vicarious liability. Now, those are two problems which are peculiar to the Roman Catholic Church. But the next issue is limitation issues, and that's a problem which is general. The limitation regimes in Australia vary enormously from state and territory to state and territory. The toughest is Queensland, the most liberal is South Australia, New South Wales is somewhere in between. Getting an extension of time in New South Wales is difficult but not impossible. But there is a case in which the High Court said there is a general presumption against an extension of time. It's a case called Brisbane South. In that case, it was said memories fade, circumstances change, the chances of a fair trial still being available are the ultimate test. Now, I ran a case I referred to earlier in respect of a boy abused in a Salvation Army institution at about 8 in 1963. And ordinarily, you wouldn't get an extension of time in New South Wales, but because this had occurred in South Australia, the New South Wales court was applying the relatively liberal South Australian law. It's the Lex Loci, the law of the place where the injury occurred, which determines what regime you're applying for an extension of time under. Even then, we would have had great difficulty if it hadn't been for the fact that the Salvation Army really was hoisted on its own petard. It chose not to put on any evidence from anyone who had come from the institution, and put on, as you can do on an extension of time application, information and belief affidavits merely from solicitors who said, I've been informed and truly believe that this is what occurred. Now, that information obviously doesn't carry the weight of direct evidence, but nonetheless they could get it, and it's very difficult to test it. But in this particular case, they came unstuck because one of these solicitors, and I'm glad to say they were Victorian solicitors for the church, for the Salvation Army, and not New South Wales solicitors, one of the solicitors said, the psychiatrist who attended the institution and who treated children, his records have all been destroyed, and we're therefore prejudiced. We checked with the psychiatrist. He said, yes, I've destroyed my records, but I never actually treated children at the institution. I merely followed up children I had previously treated. So your client could never have had any records to be destroyed. And the court made a finding, both at first instance and the Court of Appeal, that the solicitor had sought to mislead the court, and that was destructive of the credibility of the Salvation Army. The other solicitor put on an affidavit in which he said that the deputy head of the home has died, and we're therefore prejudiced and you can't have a fair trial. We then managed to establish the little thing that they had omitted to say, namely that the death had occurred long after the allegations had been made, proceedings commenced, and they had taken a full and detailed statement from him, which would be admissible in evidence. And that little fact had been left out, and again, the court made adverse findings about the solicitor, and those findings were upheld in our New South Wales Court of Appeal. And there were then professional conduct complaints against the Victorian solicitors in Victoria. We got our extension of time largely because the Salvation Army, through its tactics, had shot itself in the foot. Ordinarily, it would be very difficult to get an extension of time going back to 1963, although in a case of an Aboriginal child who was taken wrongfully from the child's parents in the early 1950s, a case called Trevorrow, run by my colleague Julian Burnside QC in the Supreme Court of South Australia before Justice Gray, who was a great draw for a plaintiff. In that case, he got an extension of time to sue the state of South Australia, and got access, because this child had been made a ward of state, got access to the Crown Solicitor's advices, because the Crown Solicitor should have been protecting him, not advising against his interests. Great piece of work, but very, very difficult. Extension of time cases are hard, not always successful, and there's many cases in which, sadly, you've got to say, I don't think you have sufficient prospects of getting an extension of time to make it worthwhile having a go. And there's all the prospects that you'll get an adverse order for costs, could be hundreds of thousands of dollars, you'll lose your home. So you have to warn people of that, and we as legal practitioners have to certify that a case has reasonable prospects of success, not a certainty of success, not even a probability, but a reasonable argument. If we think a case really is doomed to failure, we are liable to be struck off for running proceedings in respect of it. So limitation problems are very real, and I'll come back to the solution to that in a moment. I thought I'd say something generally about the work of the Commonwealth Royal Commission. Justice McClellan has been doing an extraordinarily good job, as have the other commissioners. The Ellis issue was aired for about 2 weeks of hearing. They started with the most junior of the officials in the Roman Catholic Church and worked their way up to Cardinal Pell. The documentation that was extracted from the church and used ran to thousands and thousands of pages. It was very powerful. At the end of the day, Pell had to acknowledge that he had allowed his solicitors to run a case that John Ellis had not been abused, when the church had, through its own internal processes, accepted that he had been abused. McClellan gave the solicitors from Cause an extremely hard time. It could be argued that the senior and junior counsel were very lucky not to cop the same treatment, but also gave Pell and his subordinates a very hard time for running a case that they knew to be false. So interesting, very powerful. We haven't got the recommendations yet from that, but we expect the interim report of the Royal Commission into the issues I've been talking about, that is legal liability, about the middle of next year. The other inquiries have been similarly well handled, very professional, very well organized, and the work that's been done you've seen in the papers and you've heard about. The 7:30 report has followed it very well, and so has AM and PM. There's been some excellent stuff done by the Royal Commission, and I am really genuinely hopeful that some major recommendations will come out. But even just the airing of these complaints and these issues, the number of those that I see who say, look, even if I can't get any compensation, at least I've had a hearing, at least someone has listened for the first time. I've never thought I'd be able to talk to anyone and tell them what had happened, and that they would actually want to listen. And they've been treated by the Royal Commission, whether it's in private session or in public, respectfully. They've been cared for, they've been counselled, and they've been assisted. And I must say it's been a great effort so far. So I think in terms of institutions generally, and while I focus on the Roman Catholic Church, institutions generally, there's a major problem in this country. It's no different, sadly, to what's been seen in Boston, seen in parts of Canada, seen in Ireland, perhaps worst of all in Ireland, and seen in England and Wales. And we've heard of reports, of course, from Belgium and the Netherlands. There's not, sadly, it seems to be a worldwide issue. But the Royal Commission is taking a major step forward to doing something about it.
Question.
Please.
I just wondered if you think there's any possibility at all that there will in future be some kind of stricter or any kind of state supervision of an institution like the Catholic Church. I can't myself see it happening. What do you think?
The Royal Commission has asked for submissions on that topic. I wrote the submissions for the Australian Lawyers Alliance. I had a hand in the submissions for the Bar Association. I will be very surprised if they don't come down with very firm recommendations. There are working with children rules in every state and territory in Australia. Their effectiveness varies, and their implementation varies significantly. I suspect that they will recommend standardization of those systems, but they also have asked specifically for what we suggest in terms of supervision of institutions. And look, some of the worst abuse has not been necessarily in religious institutions. Some of the worst abuse has been in state-run homes. Some of them have been little short of slavery. And the physical abuse as well as sexual abuse has been absolutely horrific. So the problem is, who do the inmates in a state institution get to complain to? They have no access to lawyers. They have no access to the outside world. Their abusers are the only people they're allowed to report to. It's a problem, and I expect the Royal Commission will be making recommendations in respect of that situation, in respect of institutions and homes run by state institutions and by religious institutions. And I don't think there'll be a difference between the two. So I'm reasonably optimistic on that front. I'll be very surprised if they don't come down with some strong recommendations, given what I've heard fall from Justice McClellan in his comments from the bench, and he's been quite scathing on occasions to people like Pell and others. Now, sadly, and just before the Royal Commission was announced, there was a special commission of inquiry into the huge number of abuse cases in the Maitland-Newcastle diocese. Now, that special commission of inquiry was very limited in its terms of reference. It was set up under the previous Premier. My colleague, Margaret Cunneen, was appointed to run it. She's has been a Crown prosecutor over many years. But their terms of reference were very limited, and they were looking specifically at the allegations that Detective Inspector Peter Fox made against the police. And that was the limit of their inquiry. They obtained some incidental information about the abuse and about its cover-up within the church, but they made adverse findings against Peter Fox, which, from my knowledge, seem somewhat over the top. Peter Fox may have lost his sense of perspective, but frankly, we wouldn't have a Commonwealth Royal Commission if he hadn't come forward. And the same in relation to Joanne McCarthy. There were no adverse findings about her. She's a reporter on the Newcastle Herald. And she's the one who published a front page, on the front page, of the Newcastle Herald, a letter from a very senior clergyman who we all know, but I'm not allowed to name, who told McAlinden that if he didn't agree to be defrocked, there was a very real risk that the police would become involved. That clergyman's, that very senior member of the clergy, now very, very senior in the church in Australia, has been referred to the Director of Public Prosecutions for consideration of prosecution, and it'll be very interesting to see what happens. He's consistently refused to talk to the police, which doesn't surprise me, and I suspect there may be a prosecution, but we'll wait and see. But what did disturb me was the fact that the police up there, they had a task force, they'd done nothing for 10 years. I went up and with Joanne McCarthy and spoke to the police. They're very junior police. They were extremely hesitant to do anything. They hadn't got a warrant to examine the records of the Roman Catholic Church. Joanne McCarthy was the one who had extracted these documents from sources within the church. To my mind, and I told them so, they had enough information to charge that particular clergyman on what they had. They wanted witnesses to come forward because these junior police officers had no training in handling those who had suffered abuse. They had done a very good job of frightening off the witnesses who were refusing to cooperate. Joanne McCarthy managed to persuade some of them to come forward and assist, and some of them did give evidence to the Special Commission of Inquiry, but I don't believe that police investigation was ever going anywhere, and every time they got close to making any recommendations, the police officers would be moved on and new and very junior police would replace them, and it had been going on for 10 years. So until Peter Fox went public, nothing in my view was going to happen, and Joanne McCarthy did a great job up there, virtually single-handed, in bringing this to light, and between the two of them, I think, bringing about the Commonwealth Royal Commission. Well, the findings of the Special Commission of Inquiry, I thought, were very harsh on Peter Fox. That's my personal feeling. Yes, I think he lost his sense of perspective and became a zealot about the issue, but I think there was good reason to suspect that the police were not very interested in pursuing these matters. I'm not a great conspiracy theorist myself. I'm more inclined to the view that incompetence is always much more likely than a conspiracy to cover up. But I can understand how Peter Fox came to a different conclusion, given his bitter experience with the police, and he was a relatively senior officer. I thought the way the police were let off so lightly on the grounds of lack of resources was, well, to my mind, very surprising in the light of the lack of enthusiasm for doing anything about a huge problem up there. But I thought I'd just give you one example where I thought the Special Commission of Inquiry both got its findings right and got its recommendations wrong. And this is a person I can name. Many of you will have seen the Secretary of the Bishops' Council, Father Brian Lucas, on television, and heard him on radio saying he didn't see why he should step down, he hadn't done anything wrong, there'd been no adverse findings about him. Well, not so. And I won't be saying anything defamatory because I'll be using the words of the Royal Commission, or the Special Commission of Inquiry, I should say. That Special Commission of Inquiry found that a priest, Father McAlinden, had sexually abused a substantial number of children, and that Father Brian Lucas, General Secretary to the Australian Bishops' Council, was aware of this but failed to report it to police. Indeed, his job over decades was to deal with abusive priests and get them to quietly retire without a scandal to the church. The Special Commission of Inquiry said that whether falling within the pre-1990 offence of misprision of felony, a very old common law offence, or the post-1990 equivalent Section 316 of the New South Wales Crimes Act, that is, concealing a serious criminal offence, these findings of serious criminal conduct, knowledge of the commission of such offences and failure to report to police meet all but one of the criteria for consideration of prosecution. What was the criteria that wasn't met? The Special Commission of Inquiry said, in respect of this, quote, there is sufficient evidence of each of the first three elements of the offence under Section 316 of the Crimes Act. The answer given was that it was likely that in any potential future criminal proceedings, Lucas would be sufficiently able to raise the issue of reasonable excuse. That is available under Section 316, on the basis that a witness to whom he spoke, A.J., did not want the matter reported to the police. Interesting. AJ gave sworn evidence to the Special Commission of Inquiry, and these are the Special Commission of Inquiry's words: Father Lucas never asked me at any time if I want to take my complaint to the police. Equally, I never raised it either, but then again, I never got the chance with him. He just wanted the facts. It was a short 3 to 5 minute phone call. Well, one would have thought that in those circumstances, whether there was a reasonable excuse would be a matter for a jury, not for the Special Commission of Inquiry. But in any event, let's accept that that Lucas might be believed over the person who is said to have not want to go to the police. Lucas met with McAlinden in February 1993, and whilst, as in the Father F matter, which was also notorious and which you probably know about, he, strangely enough, has lost his memory of what happened, and he intentionally kept no notes. That was his practice in all of these cases, and he was quite strongly cross-examined by Justice McClellan about that in the Royal Commission down in Wollongong. The Special Commission of Inquiry found, quote, there is reliable evidence confirming that at the meeting McAlinden made admissions of having sexually abused children. Consistent with his stated practice, Lucas reported those admissions to Clark. That evidence alone, I would suggest, was sufficient to require Lucas to go to the police under Section 316. The Special Commission of Inquiry went on to find, quote, from 1993 onwards, Lucas possessed information, including admissions of sexually abusing children, that would have been of interest to the police and would have facilitated a police investigation of McAlinden. Lucas failed to report McAlinden to the police. He should have done so in 1993, as should have the diocese. Well, why then is he not facing the possibility of a charge through the DPP under Section 316? The Special Commission of Inquiry gives no explanation why that confession directly to him shouldn't have caused him to go to the police, or how he could have any reasonable excuse for not doing so. Just total absence of any explanation. Again, the Special Commission said, in their conduct in connection with McAlinden in 1993, Lucas and the diocese failed to have proper regard to what should have been the overriding consideration, the protection of children. Well, doesn't that say it all? He's going round as spokesperson for the Bishops' Council. It's a rather sad state of affairs. We, through the Australian Lawyers Alliance, have written to the Attorney General in relation to this matter, and I've done what I can in other quarters, as recently today, to see if something can be done to deal with a, in my view, a manifest deficiency in that Special Commission of Inquiry.
Could he be picked up by the Royal Commission?
Yes, and we've written to the Royal Commission asking them to do so. So we'll see what happens.
Could you speculate as to why Fox was treated the way he was?
All you can say is that the police were very gently treated. Fox was very harshly treated, and in general, and apart from the one very obvious potential prosecution, the rest of the clergy involved seem to have been treated extraordinarily charitably. The Section 316 prosecutions are extraordinarily rare. There's only been one, and the priest then died before that prosecution could be brought. But it follows an old offence called misprision of a felony, which was exactly the same, and which was revived by Lord Denning in the English Court of Appeal in about 1961 or thereabouts, in a very powerful judgment. Essentially, the offence doesn't involve actually concealing anything. It merely involves knowing of a felony or under Section 316 a serious criminal offence, and not reporting it to the police or other appropriate authority without reasonable excuse. So all of us, if we become aware of a serious criminal offence, are required to go to the police or other appropriate authority and report it, and all the information we know about it. That's our obligation under the New South Wales Crimes Act. There is one other peculiarity about it, and that is that a prosecution under Section 316 requires the agreement of the Attorney General. But my understanding, at least with the previous Attorney General from my dealings with him, is that despite his connections with the church, he wouldn't stand in the way of a prosecution. I would expect the current Attorney General to be the same, but I'll know more when I see him in a couple of weeks' time. I mentioned earlier the Victorian Legislative Council committee recommendations, and they did an extraordinarily good job. Generally speaking, upper house inquiries are very difficult things. I've just been to Canberra a couple of weeks ago to give evidence to the Senate inquiry into Manus Island, and my suspicion is that that inquiry will go absolutely nowhere. Unusually, this Victorian upper house inquiry, after our initial doubts, ended up being well-resourced, well-managed, and even though the members of the upper house don't necessarily have any particular legal training, they got good legal support from the government, and were ultimately able to do a fine job of dealing with the issues. And they were dealing only with religious institutions, but nonetheless they did an excellent job down there. These were their primary recommendations: requiring all churches to have incorporated legal status so they can be sued, making churches vicariously liable for their personnel, including clergy and teachers, and removing, not just temporarily lifting, but removing the limitation period. And for the reasons said earlier, that makes enormous sense. What's our position in New South Wales? David Shoebridge of the Greens has produced a bill which has had its second reading, and actually a surprisingly respectful second reading in the Legislative Council. It's the Roman Catholic Church Trust Property Amendment Bill 2014, and it proposes to remove, first of all, the non-legal status of the church, that is, to force the Roman Catholic Church to be incorporated so it can be sued, and to make the trustees of its property, I think, was it, I'm just trying to remember from the Royal Commission, Cardinal Pell was required to disclose the property assets. I think it was something like, there were billions of dollars in the one diocese alone, and I think they had a special fund of about 1.4 billion, which was producing about $40 million in earnings a year. So Cardinal Pell conceded that they could meet any conceivable claims that would be made on them. It was interesting because their valuation, because they're a charity, they have no tax liabilities, they don't have to have up-to-date valuations. Their property valuations were all as at the date of purchase, so many of them were in pounds, shillings and pence. So their billions of dollars were obviously a pretty gross underestimate. There's nothing improper about that, but when it's sometimes said that they are one of the wealthiest organizations in Australia, I suspect that if they were properly valued, that might change to being the wealthiest organization in the country. The second aspect of David Shoebridge's bill is to make the church vicariously liable for the conduct of its clergy, teachers, and others, such as social workers. And that's also a no-brainer as far as I'm concerned. The third aspect of the bill is a 2-year lifting of the limitation period. And that's the aspect on which I have some disagreement with David Shoebridge. I know he's done that because he thinks he might have a slightly better chance of getting it through. My view is a at least from my discussions around the place, that I don't think a Greens bill is going to get up. Regardless, there is a much better chance of government legislation, frankly, to do the same thing. And I would much rather have a total lifting of the limitation period for criminal sexual abuse of minors, and totally lift the limitation bar. Because otherwise, if you merely lift it for 2 years, those who have been abused, the 50% of people who were abused in the last 22 years, the greater proportion of them won't have come forward in time to lodge a claim, and they'll be back to the old limitation regime, and the multiple possibilities and permutations under the New South Wales Limitation Act 1969, with which I'm regrettably more familiar than I'd like to be. The other thing I just thought I'd draw to your attention was a couple of one case an essay and another case a book. David Marr is a journalist and who was sitting with me at the Royal Commission for quite a long period of time now. I've got to know him quite well. Has written a very good article on George Pell in the quarterly essay called The Prince, Faith, Abuse and George Pell. It makes interesting reading. The other one is a book by Kieran Tapsell, who's been a former acting judge like myself, and he's writing in this book called Potiphar's Wife, The Vatican's Secret in Child Sexual Abuse. And what he points to is that there was a papal encyclical in 1922 directing that all clergy not refer any abuse cases to the civil authorities. And he points out that although it was modified in, I think, 2004, it remains in force and continues to remain in force even under Pope Benedict, and despite his words and his seeing of victims in the last few days. It's rather a depressing picture, but nonetheless worth knowing about. Can I invite at this stage any questions? The question I was asked was whether any of the people coming forward have been threatened with defamation proceedings if they made the allegations and they were found to be unfounded. Answer: yes. In that case up at Port Stephens, when there were a number of complaints about inappropriate conduct, in that case by a teacher, not by a member of the clergy, the head teacher of the school, who had not, of course, been told of the teacher's prior history, met with the parents and told them and threatened them, with a representative of the Catholic Education Office present, that the teacher had assured her that there'd been no inappropriate conduct, and that they would be subject or at risk of defamation proceedings if they pursued the matter further. Sadly, yes, that has occurred. In general, however, the best threat the churches have is costs, because if you fail in your case and you get an adverse order for costs, well, in John Ellis's case, the costs order against him was $600,000 or $700,000. And now the church ultimately never pursued it, and after he saw Pell personally some years later, Pell, in an apology to him, said that they would give it up, but they held it over his head for several years, and indeed they tried to dissuade us from going to the High Court by saying, we'll drop the adverse costs order we've got if you don't seek leave to go to the High Court. Very unattractive conduct, but sadly, it's the way it is in our litigious system, and there aren't really much in the way of alternatives to it. The question was, has there been a change in jury attitudes towards conviction of people for child sexual abuse? I think the answer is yes. Generally speaking, in the 1960s and 1970s, I don't. I think there was a great deal more ignorance in the community, not total by any means, and these things happened, but they were generally hushed up. There was no mandatory reporting rules. There was a breach of the common law duty, but in general these things were kept fairly quiet and dealt with in various ways. And in general, you wouldn't expect that a jury would have much insight into the prevalence of these activities or the overwhelming likelihood that children who are prepared to go into a witness box, and former children, are very likely to be telling the truth. The instance of false evidence is pretty small. We know that now, and in Ms. Caneen's favour, when the period she was talking about when she was giving evidence in relation to the swimming issues, in fairness to her, she was advising the DPP not on whether or not she thought the offences had been committed, but whether a jury properly directed was likely to convict. And the matters that she raised, unfair though it may in a sense be to the girls, would at that time have had a very real chance of persuading a jury that the case had not been proven beyond a reasonable doubt. Now, in the civil courts, different matter, balance of probabilities. Those cases might well have been able to succeed if those girls had gone to a lawyer who'd been prepared to take the case on and act for them on a no-win, no-pay basis, because there is no civil legal aid left in this country apart from some for Aboriginals. So they'd have had some real prospects of a civil case, but a criminal case, yeah, I can understand at that time the difficulties. Different matter today. I suspect a jury today would be much easier to persuade of guilt beyond a reasonable doubt. So you're right. I think there's been a real change in public knowledge and public attitude, and that's probably all for the good.
Is there any change in the way evidence can be taken from quite small children these days?
The answer is yes. For a considerable period, it's been possible for the child to give their evidence from another room on video link, so that the jury sees the child. The child doesn't have to look at the abuser. In one case which I've got coming to trial in August, where the abuser, the stepfather of these two little girls, now grown women, abused them and was ultimately convicted. The experience of giving evidence back in the early 1990s was totally traumatic to them, because apart from anything else, he made throat-cutting signs to them and in other ways made it quite clear that he had it in for them. Fortunately, he went down for a long time. But yes, the courts now have pretty good methods now of protecting children, and judges will be very careful in the way in which they allow cross-examination to take place, and cross-examination is quite limited, particularly in respect of young children. So yes, I think we've learnt a lot about how to deal with these matters.
Yes, I've heard that the Royal Commission asked for more time, wasn't it? An extension of time for the investigation?
The question was, the Royal Commission has asked for an extension of time. They actually asked for an additional 2 years and for another $104 million. The Attorney General hasn't yet decided on that matter. No doubt he'll need Cabinet approval. I'm not sure if Mr. Palmer will have left any money in the kitty at all by then, but the Attorney General indicated that he was favourably inclined towards it, and I'd be very surprised in the light of those comments if it isn't granted. they've had an enormous number of people coming forward, and in addition to that, there are some areas of inquiry that they would like to look into and haven't. For example, the HMAS Lewin issue is a real possibility for an inquiry on its own. That appears to have been an appalling area of abuse, and it has some repercussions for the services generally. So whilst the Royal Commission can't look into every case of abuse throughout Australia, what it's done is pick those important areas from which we can learn something and which have general application. And as far as I can see so far, they've done an extraordinarily good job of picking their targets and of extracting the relevant information before they start the inquiry. Their research has been exemplary. They would like to continue that. All of those of us who have been making submissions to the Royal Commission are certainly strongly supportive. I haven't heard anything from either side of Parliament, in the federal Parliament, which is other than support of the Royal Commission. So I would be very surprised if they don't get what they ask. The question was, when the recommendations come down, will it be state or federal responsibility? Mostly state and territory. The legislation in relation to the Roman Catholic Church is state. Most matters of supervision are state matters. The criminal law is essentially the law of the states. And because the state law varies, all the Commonwealth Royal Commission will be able to do is make general recommendations and hope that the states implement them. The Commonwealth Royal Commission is of course a joint Royal Commission with the states. All of the states and territories have also passed legislation which makes these Royal Commissioners state Royal Commissioners as well as Commonwealth to get round any procedural objections to what they're doing. But the actual implementation will largely come down to the states, though not entirely. And it'll have to be different. And whilst I would dearly like to see New South Wales take the lead in amending the 1936 Act, indeed was having something to say about that earlier today, I may or may not have any joy in pushing the state government to move ahead of the Commonwealth recommendations in the middle of next year. The Victorian government has said that it will implement the recommendations of its own inquiry, but as you might be aware, the Victorian government is well and truly distracted by other problems at the moment, and they've got an election coming up shortly, so I'm not optimistic they will be able to do anything before the end of this year. And who knows what the position will be if there's a change of government in Victoria, but the current government certainly said they would adopt the recommendations from their own upper house inquiry. But it may be a long and painful task to get the legislative changes we require, but look, just airing these issues alone is doing the world of good. You can't stop a body from investigating itself. If it wants to investigate itself, that's fine. What you should do is simply not accept that that investigation has any authority or any relevance to what should happen. You might be aware that in respect to the Father F matter, Tony Whitlam, QC, brought down a series of findings, and I've written what I hope was a pretty scathing article which was published in the Drum and Prieston magazine and elsewhere in relation to his failure to deal with the very clear evidence I thought was conceded about the knowledge of senior clergy, including Father Brian Lucas, all of whom denied that they knew that Father F had abused boys, even though the only report of the meeting, written 8 days later to the Bishop of Armidale, said he told us, and then gave chapter and verse on the boys he had abused and how. Now, I thought it was a very, very disappointing report from Tony Whitlam, and it just shows that the church employing its own lawyers to report internally are no substitute for external reporting. Now, no system of internal reporting is a substitute for the law. The law should apply equally to everyone. I think the Royal Commission will make that perfectly clear. But you don't abolish internal inquiries. You just don't take any notice of them.
You are aware that the Vatican has refused to provide documents to the Royal Commission. That means they consider themselves to be able to investigate those cases.
No, that wasn't their ground for doing. Well, it was partly their ground, but it wasn't the main ground. The Vatican did, and some of you might have heard me saying something on AM the other day about this. The Vatican claimed state immunity because the Vatican claims national status, and they declined to produce documents to the McClellan Royal Commission. That should come as no surprise. That's been their attitude throughout in respect of complaints everywhere in the world. The Vatican's representative in Ireland, the papal nuncio, who had been in the clergy in Ireland for a long time, claimed diplomatic privilege to avoid having to give evidence to the Irish equivalent of our royal inquiry. There's nothing new in that. That's simply them trying to avoid producing documents which they think might be very damaging to their image and their wealth. And it's all one would expect of them, frankly. What role the present Pope played in that, I couldn't say, but trying to change the Vatican as a newly appointed Pope must be a massive problem, I would have thought.
Look, on behalf of everybody in attendance tonight, I'd like to say a great thank you to Dr. Andrew Morrison, who's given us a fabulous presentation, and I thank you, Andrew.